Welcome, everybody. This is Raj Trivedi from White Deer Innovation. I'm lucky to be here with Josh Donovick from Skylands Legal. So Skylands Legal is an estate planning law firm right here in Sparta, New Jersey, helping families across northern New Jersey, whether it be Sussex County, Morris County, and a little bit of Warren County with estate planning. What is estate planning? It encompasses wills, trust. Josh and his team also do elder care, Social Security, disability. They have built a strong reputation here in northern New Jersey by having a 5-star view and reputation with Google, helping businesses and helping people and families for the last 3 years. And I'm very lucky to have Josh. Thanks for having us here, Josh.
Welcome. Glad to be here with you.
Thank you. I've been lucky to get a chance to know Josh throughout the last few months, as well as Elizabeth from our team. And I can tell you their attention to detail and how they've been helping families, especially in situations where it's difficult, helping people with probate situations, a lot of tough life situations. They're able to handle it in such a great manner. But what I want everybody to know is, for people that don't know you, Josh, who is Josh Donovick and how did we get here in Sparta with Skylands Legal?
How much time do you have? I mean, that's a long question, and we could. There's lots of different inroads into that. Where we might start, though, is when I was in law school, I was really interested both in estate law, the law that deals with people's property after they pass, and things like delegation of authority, and also with disability law. I wrote what's called a note. It's similar to a thesis in law school on Supreme Court decisions on the Individuals with Disabilities Education Act, which is the law that provides special education for millions of students in our country. And what I had found over the years is that mission is a crucial piece, right? And you can't simply just divert yourself into a different route because it's more convenient. I tried to do divorce litigation for a little while because I got a good job doing that, but that wasn't really the right fit for me. That the issues we deal with here are ones where I feel like I can give substantive real world help to my clients, both on the planning end and on the what we call the problem end, when we're helping people solve the problems that they encounter in the world. And we do that both with situations after someone has passed, as you were alluding to, or difficult situations where someone is losing the ability to manage their own affairs during their lifetime, to Social Security disability claims and Medicaid issues, which are maddening. They're systems where people in theory don't need a lawyer at all, but the public benefit systems are so complicated and so onerous to deal with that people really do need attorney guidance to navigate the system successfully.
That is true. I think there's so many different aspects that you do that helps families across Sussex County and northern New Jersey. And I think that one of the things that stood out to me the most after meeting you, Josh, and I think this is your superpower. I say this all the time. So before doing this, I know you were an elementary school teacher.
That's right.
And your ability, just seeing you in meetings and how he's ran meetings, your ability to make all this legal jargon simplified in such an easy way for people to understand, digest. I truly believe that is your superpower, and I think that's the thing that helps separate Skylands Legal amongst every other lawyer, estate planning lawyer in New Jersey. How have you noticed your skill sets from being an elementary school teacher? How have you applied that into this space as an estate planning lawyer?
Well, like you suggested, teaching elementary school is a lot about breaking things down into simpler and simpler pieces until you get understanding. And whether that's at the kindergarten level, the 5th grade level, anything in between, it's about simplifying so that you can build back up complexity. Let's make sure that we have strong building blocks of understanding so that we can deal with complex ideas. And I think I really take that approach in working with my clients as well. That a pet peeve of mine is that I encounter people who have important documents like wills, but have no idea what they mean or what they do. I don't think people should be signing things that they don't understand. So I really try to help my clients walk through their whole document and make sure they understand all the moving parts of it and what the real world implications of those documents are. And I think that in addition to that practice with making things simpler, teaching elementary school really reinforced to me the value of understanding, that it's not good enough for people to just be able to say, I have a will and I think it does this. They need to really understand what it's doing and what its purpose is if they're going to get value from it.
So speaking about that, the will, what is a will and why should families have one?
So a will is a legal document that gives instructions for what should happen after someone has passed on, and in particular with property. Sometimes if someone, for instance, has minor children, it'll deal with other issues like who should be guardian of a minor child or who will be trustee for property for them. But the most important things that a will are doing are really about simplifying the situation after someone has passed. We name an executor. That's the person who's going to be charged with the responsibility of carrying out the instructions in the will and dealing with the estate's affairs. We've talked about the word estate, which is extraordinarily unhelpful because people have this idea that an estate means this massive property out in the countryside that's probably surrounded by a high brick wall and, you know, they have many servants and whatnot. That I certainly have that idea in my mind too, but the word estate to a lawyer really means someone's property. That an estate is the legal part of ourselves that holds our property, and we don't notice that in any main particular way for the most part while we're living, because we just manage our own estates unless something happens where we need guardianship or something like that. But after someone passes, their estate survives them and continues, and the executor has the responsibility of dealing with it. And what we hope is that the will is going to give clear and specific instructions on what should happen. The biggest problem I see with them is the things that are left out of wills, things that where there should be a clear or specific instruction and there simply isn't. And that's the fodder for litigation, for people getting involved with the court system when there's not an answer in the will. Sometimes clients will ask why our documents go on at enormous length while they've seen other wills, maybe their own existing will, which is a page or two. And what I tell people is that a will or a trust is like a playbook, that no matter what life has to throw at you, there should be an answer in the document about how it should be addressed, or at least a framework for addressing it.
You mentioned trust, right? I hear this all the time. Like, what is the difference between a will and a trust?
Sure. A trust is a separate legal entity, similar to the idea of an estate, and it can be either set up during someone's lifetime or after they pass. The best analogy for thinking about trusts, I find, is corporations, because most people are familiar with the idea of a corporation, that it's usually a business that exists on its own. It has shareholders, it has officers, but there's not one person who is the corporation. It's the same with the trust. The trust is this separate kind of entity. It has its own body of law that's different than corporate law, and that it can do things like own property. It can have its own checking account. It can own a house. A trust can really do a lot of different things. And that's where all of the complexity comes into. It's an extraordinarily flexible type of legal entity. Broadly speaking, there's two big piles. There's what we call living trusts, trusts that people set up during their lifetime, and testamentary trusts, which are created by someone's will. They serve different sorts of purposes. There's also a distinction between revocable and irrevocable trusts. One, you can modify, amend, revoke completely as much as you like during your lifetime. The other type is sort of set it and forget it. You set it up and it is irrevocable. It cannot be changed. It cannot be amended without court intervention. But there's lots of different types of goals that people can accomplish with trusts. And you have to make sure that you're working with an attorney that really understands the playing field to make sure you're getting something that is carefully crafted for the goals you're trying to accomplish. There are basically two big things that people will express to me as reasons they need trusts. And sometimes people will come in and say, I don't want a will, I just want a trust, which I've seen the guidance that leads people to that thinking on the internet, and it's bad guidance. The biggest reason that people say they want a trust is to avoid probate. But the people saying that may not even know what probate is. Probate is the legal process of having the will accepted by the court and empowering the executor to go out and deal with the estate, and can also mean that whole process of dealing with the estate. If something's in a trust, it's not subject to your will. The directions will simply be whatever the trust says, because a trust, after someone passes, simply continues to exist. The trust should name a successor trustee for that scenario, but nothing about the trust or its property changes when the initial creator of the trust passes on. The difficulty, though, is that avoiding probate may or may not be really a helpful goal. In New Jersey, we're blessed with a relatively straightforward probate process. There are some states, Florida, California, New York leap to mind, where they have notoriously difficult probate processes, and where avoiding it may have more value than it is in New Jersey. But for most New Jersey residents, unless they have out-of-state property or some sort of complex property ownership arrangement, maybe multiple family members owning something, then there's just not a lot of added value, especially when you start thinking about, to get that value, you have to move your assets into the trust during your lifetime. The other big goal that people will talk about is different types of protection: creditor protection, Medicaid protection, tax protection. All of this stuff comes from irrevocable trusts, from the irrevocable trust that you can't change. And to get any of those protections, essentially, you have to be willing to put something into the trust and give up control of it forever. It might be still for your benefit, depending on how the trust is set up, but you're going to be giving it into the custody of an independent trustee, someone who is not bound to obey you. And you get the protections that people want by essentially making the things in the trust not your property anymore. And so that's a very challenging goal, and we have to make sure that the goals are both realistic and closely tailored to both what the trust is doing and what the law allows.
Yeah. Josh, it's very clear that you have a vast knowledge of this in depth. And I think that people don't realize how complex it can be to create these things, whether it be a will and a trust. For those that are thinking, I can do this myself, I can create a will myself. Why do you think, tell me a little bit about, creating a will yourself versus going to someone like you as an expert in this. What are the pros and cons of each?
Well, it's very easy to make a legally binding will. And that's that's where the problem essentially lies, that anyone can go out and do this very simply. To have a legally binding will, the document needs to say it's your will. It needs to be signed and dated by you. And you need to have 2 witnesses. If you've accomplished those goals, you've probably got a legally binding will, whether or not that's good. And lots of different kinds of problems can arise. Some of them are the things that are left out. Some of them have to do with not understanding the ramifications in the law of different types of arrangements. I can think of a couple of DIY wills I've seen that have had disastrous ramifications because someone didn't understand the underlying law. I'm thinking of a person who, in his will, had purported to give his house to his present wife, who was not the mother of his children, and for her lifetime. And then essentially it would go to his children after. Now, that all sounds fine on paper, and you can do something like that in your will. The problem was the way that he owned the house. The house was owned by him and his wife by what's called tenancy by the entirety. And if you're a married couple and on the deed to your house, it says to so-and-so and so-and-so, husband and wife, or a married couple, something like that, you probably own your house in this form too. And what happens with this form of ownership is that if one of the spouses dies, it becomes the other spouse's property outright by operation of law. No new deed needs to be executed. The will doesn't touch it. None of that. So when this gentleman passed, his wife became the owner of the house. The instruction that it was supposed to be for his lifetime had no effect for her lifetime, because it wasn't his property to give away after his death, because it was simply hers. I'm thinking of another pretty common issue I've seen where we set up wills that are not mirror images to each other. And there can be reasons to do this, but typically when we're doing wills for a couple, we want them to reflect each other and to lead to the same outcomes regardless of who passed first. And so the wills I'm thinking of said, to my spouse and then to my children. That's a perfectly normal, common arrangement. The issue was that they each had their own children. It was a later in life marriage. They each had their own set of their own children. And their wills said, this person's my wife, these people are my children, referring to their own children. And then if my spouse survives me, they take everything. If they pass before me, my children take everything. The couple passed within a year of each other. The husband died first, so his estate passed to his wife. She died second, so her will instructed that everything go to her children. His children were completely disinherited by the accident of him passing first. Everything to my spouse and then to my children sounds good and normal and natural, but you have to look at the ramifications in the real world to exactly what you've put in. And unless you're practiced about thinking through these issues, it just might not occur to you. So first of all, I think people should always use a lawyer. Now, you can pay lawyers very, very different amounts of money for what are on paper the same documents. And what my recommendation for most people is to find a lawyer who specializes in estate planning as opposed to a general practitioner. Now, general practitioners are trained in the law of wills. They can also create a legally effective will for you. The difference is that they are not spending all of their days thinking about the issues that surround all of this. They're not dealing with the problems that arise when things go wrong, typically. That's when people often find themselves needing to seek out a specialist. So that's the other question frequently is, why should I pay more to a specialist than when I can pay a fraction to a generalist? Well, in some ways you get what you pay for. And then I would certainly recommend going to a generalist over doing a DIY will, unless you have a lot of education around it. But it's about risk tolerance fundamentally, and how much do you want to invest to make sure things that are orderly and simple.
Got it. I know people are going to be thinking about this. What happens in the state of New Jersey if I die and I do not have a will?
Sure.
What happens to whatever I own?
It invokes a complex set of laws that are referred to as the laws of intestacy, the laws of what happens when someone has no will. And there are two big pieces that you need to look at. Who's going to be in charge and how is the property distributed? Depending on someone's family situation, it could be the same result as they would put into their will, but it might not. The law sets out a strict hierarchy of priority for who can be the administrator of your estate. It follows a pretty natural progression of its spouse, children, parents, and so forth. And it may follow what you would do for yourself, but we can think of lots of scenarios where it doesn't work. I have a client where we recently created a will that the only issue really being solved was that she was still married to her husband that she had not been in a relationship with for decades. So under the law of intestacy, he would be her sole heir, he would be the priority to be the administrator, but her setting up a will upsets that, and she can decide who she wants to be the executor instead of it being on the say-so of someone she doesn't really have a relationship with anymore. And the property situation, again, often will follow the sort of natural flow of things, that It's typically everything to your spouse and then to your children, unless you have children that are not the children of your spouse, and then they get a separate cut right from the get-go, which is often not what people are doing in their wills. And again, we can think of lots of scenarios where this is just not what people would want. I have a couple who are my clients where they had raised their nephews but had estranged children. They wanted everything to pass to their nephews ultimately, and not to the children who they didn't have relationships with anymore. So, but in the law of intestacy, the nephews wouldn't see anything. It would only be their children who have rights.
Gotcha. Yeah, those situations are people don't think about any of that, right? And it's unfortunate that we go through a life sometimes without even getting a will. And I know a lot of the clientele that you have are people that are over the ages of like 55. But for the people that are younger, that have younger families, can you speak about why it's important for younger families to have a will?
One thing I'll touch on before I circle into that is I think part of the reason many people are seeking out estate planning services when they're older is not just that they're later in life thinking about different issues, but there's been time for them to see how things can go wrong. It's very common that someone is in my office for planning services, and I ask them, what brought you here today? And I saw what happened in my dad's estate, my brother's estate, my best friend's uncle's estate, whatever it is. And they've seen the problem, and so they know they need to get ahead of this. What younger families should be concerned about are the care of children, and that is both the care of the children themselves and the care of their estates, of their property. The will can deal with this by nominating guardians and nominating trustees. What I recommend is typically not to have a situation where money can pass directly to minors. First of all, we know there's lots of reasons not to give large sums of money to minors. They're not equipped to make good decisions. And we know that young adults face a lot of the same problems. So my typical recommendation is, if there's any chance that young people will inherit, that we set up testamentary trusts within the will, where the will is essentially going to say, something like everything to my spouse and then to my children. But if my children are under the age of 25, then instead of going directly to them, it's going to go into a trust for their benefit, a trust in their name, with a trustee I've named as the custodian of their money. It's another one of these areas where we create a lot of simplification this way. If a minor inherits in New Jersey, typically the surrogate court is going to have custody over their resources, and a guardian, even if that guardian is their natural parent, a guardian of their estate needs to be appointed to manage their money. There's going to be court oversight. There's going to be a bond that needs to be paid. This is one of the other things that happens when there's no will, is in the will, we waive the necessity of a bond. We say we trust our executor. They don't need to get bonded. And we say that we don't need court oversight for everything when we have a will. That simplifies the situation enormously, because the default is bonding and court oversight. And so if you have a minor inheriting, that's all going to happen. If you set it up in your will, it can flow into a trust that sets out its own rules for how it's going to be governed. Trusts are very flexible. You can have it work the way you believe it's going to work for your family. And you can put the person that you trust with that responsibility in the key position. Guardianship deals with the actual care and custody of minors. And we typically want to name guardians in wills if there's any chance that someone could pass while their children are minors. And often that's the same person we're nominating as trustee, that we trust the person with our children to manage both the child and the money. But it doesn't have to be. I've had plenty of people tell me things like, my brother's a wonderful guy. He has terrific values. He knows my values. He would raise his children as his own and as I would want. However, he's terrible with money. So he can't be the trustee. We have to think those things through. And sometimes people are very concerned about issues of will people be offended? And of course you have to be concerned about that. but it's more important to put the right person in the right job. Trust is the most important issue that I deal with.
Yeah, trust is number one, it sounds like, when it comes to this situation. Even when you're talking about like the co-executor aspects of it, it's tough when you have kids you have two kids, you don't want them to feel a certain way, but you have to make those decisions.
And you're looking at two responsible, trustworthy people. I'm thinking of another client where that was really the only issue. She was a widow. She had two adult children who had children of their own. They're married, had jobs. We're doing all of the things we hope our children will do over time. And there was no reason to think of either of them was dishonest or was going to not do the job. But the problem is that they don't get along. And we had to think very carefully about how do we balance this, because what I try to caution people about is really two things. One, grief and money are poor bedfellows. And when they get mixed up together, sometimes people behave in ways they would not ordinarily. Yeah. So we need to have a little bit of reality about that. And the other thing is really that people have sometimes competing ideas of the good. It doesn't have to be there's a bad actor. I think this is right. I think this is right. And boom, we are stuck.
Man, that's tricky. And that's always tough to deal with, but that's just something, that's why they have people like you to help facilitate that and come up with that advising for what is the best plan for certain families.
And I like the way you put that, because I don't take a paternalistic view on what people should do with their estates. I advise people on risks and benefits. I advise people on what I view pitfalls as. Sometimes I will strongly recommend away from what a client wants to do, but ultimately it's the client's decision within certain bounds about how we go about things. And, again, thinking about, say, the children, where we have this question of trust and will they get along, say to them, ultimately, your children, I don't.
Right.
It's your judgment call as to whether this is a potential problem in your family or if it's not. And I will advise them on what I view in the abstract as the risks. I'm always looking for the low probability, high risk event, things that are unlikely to happen, very unlikely to happen frequently, but have catastrophic consequences if they do. We don't want to leave things to chance, even if the chances are very small.
Yeah. And speaking about that too, I know in your wills, you have a section where for the last case scenario, the worst case scenario, there's a thing called like the beneficiary of last resort.
Yeah.
Right. Can you speak about what that is and why that's important to include in a will?
We always want to make sure that we are doing contingency planning in a will, that we hope that people will pass in the order that we expect them to, in what we view as the natural order of things, that one generation will pass and then the other, and that the people we expect to be available will be, but we don't know. And I ask people to think about, catastrophic scenarios that are extraordinarily unlikely, difficult to think about, but we need to think through things like we're all together on a plane and it goes down. Whole family is wiped out at one blow. That's an awful, awful thing to contemplate. But if someone has a will that no one can inherit from, you've exhausted everybody, then the state has a good chance of becoming your heir, which even the state recognizes as a bad outcome. So we want to avoid that. And what I recommend people do is that if they can think of other individuals they would like to benefit, that after their main plan, they have essentially a second line of people to inherit from them. And after that, or if they just don't want to name a second line, that they name a beneficiary of last resort. And then I recommend that they choose a charity or a religious organization, something that's not dependent on the life of any particular person, to be that beneficiary, so that if worst comes to worst, it's not going to the state, it's going to a cause you care about. And it's a perfect example of what you're talking about, because the odds in any particular estate of that ever coming into play is extraordinarily low. And especially when I'm talking to people with grandchildren and great-grandchildren, they've got like 30 descendants, odds are very, very low that this person is going to be in this situation, but we still have to account for it.
Yeah, you still got to, right, you're right. You never know the unexpected, right?
Exactly.
One of the things that I think people are going to be interested about is, how frequently should they be reviewing a will? How frequently should people be updating a will? What are those situations? Like, what does that look like?
It depends. What I would say in a vacuum is that someone should take a fresh look at all of these documents every 10 years or after major life events like marriage, birth, death.
Gotcha.
Now, it all depends, though, on what you have in place and what the events are. Like we've been talking about, my intention is that we design a document that's going to stand the test of time, that the wills remain legally valid forever.
Okay.
So we need to think about this 35-year-old making a will with me might have this will 60 years from now. And will it be sane in that circumstance? And we need to make sure the answer is yes. And now, will I hope that person takes a fresh look with me or with someone else in between those 2 points? Yeah, of course. But you have to think about very long-term timeframes with these kinds of documents. What is this going to look like 25 years from now? Often people will ask me about, especially older clients, about transferring property to their children during their lifetimes. And there can be good reasons to do it, and there's advantages to doing things like that. But when people are thinking about, say, moving their house into the names of their children, and that person is 75, and say, listen, you're in your 70s, life can change rapidly, health can change rapidly, but you're sitting here healthy and whole today. We need to be thinking about at least a 20-year time horizon, even for a 75-year-old. So 20 years is a very long time to count on no changes in a relationship. And if you've transferred your most important asset, your residence, outright into the hands of one of your children, and we are expecting that relationship will stay perfectly stable and healthy and happy over the 20 years, well, I certainly hope so. No one is planning to become estranged from their child, but it's again easy to think of scenarios that could cause problems. There's a divorce, there's a marriage, someone has a health problem that changes things radically, and suddenly we could have a very unstable situation for someone.
Gotcha. I'm curious, if somebody has a house, let's just say in Florida or New York, and then they moved to New Jersey, and they had a will already created from Florida and in New York, and now they plan on living in New Jersey for the rest of their life. Do they need a new will?
First question.
Yeah.
Are they keeping their Florida and New York properties?
Let's just say for this, yes.
Okay. And it may influence the answer.
Okay.
First thing that people should know is that if you move states, you should have an estate lawyer in your new state look at your documents.
Okay.
We design them in a way where they're intended to be portable, where we say, New Jersey law should govern this will because I wrote it in New Jersey. Well, choice of law issues and conflict of law issues are some of the most complex areas of our legal system. So predicting exactly how a new will I write in New Jersey is going to behave in Texas is way beyond my licensure and pay grade. And because there may be issues in Texas that I just don't know about.
Got it.
So if someone moves into New Jersey, they should have a New Jersey lawyer look at their will.
Okay.
Whether it needs to be changed depends entirely on what's in that will. The out-of-state property issue, though, is real and a little more universal. The thing that people need to know about out-of-state property is that if you own property in more than one state, your will need to be probated in more than one state. And typically, let's say if I own a property in Florida, I pass, my will here in New Jersey would be probated, and someone would need to probate it in Florida. Also deal with their system in addition to get access to my Florida property. So even if we're dealing with states that have simpler systems than Florida, we have that duplication. So that needs to be taken into account with the plan. And a will may be totally sufficient. The virtue of wills is that they can reach out and grab any property that you own and divvy them up as long as it's carefully crafted to deal with whatever your reality at that time is. But if you know that you're going to own out-of-state property, that's actually an excellent use of a living trust, where, let's say we move the Florida property into my New Jersey trust that my New Jersey will speaks to. Nothing ever has to happen in Florida because the trust dictates who will become trustee when I pass. And then that person steps into my shoes and can start dealing with my property in trust immediately without waiting for the courts to approve. So there can be major considerations in terms of how you design things based on, are people coming from out of state? Do they own property out of state? Might they move out of state? I design things a little bit differently sometimes depending on the answer to that question. Do you think you'll ever move out of New Jersey? If the answer is yes, I'll tend to make things more conservative because the more conservative we make something, the more likely it is to work as expected under different states' systems.
Gotcha. Okay, good. Thank you for explaining that. And then just real quick, I think it's important for people to, if you can explain to the people, what is a power of attorney and why is it important?
Yeah. For any New Jersey resident, power of attorney is my number one piece of advice, the number one necessity for anyone living in New Jersey to get in place. And the reason for that is that in our state, there is no one who has a legal right to speak for you intrinsically other than your legal guardian. Minors tend to be the only people with legal guardians unless they are incapacitated. So there's always the risk for the rest of us that we might become incapacitated. Maybe I'll have a stroke or a head injury or dementia, early onset. There can be lots of things out there waiting for us that could remove our ability to act for ourselves. And with it, we'll generally take what's called testamentary capacity. That's the mental capacity to create a power of attorney, to create a will, to create a trust. Now, the bar is pretty low. The standard is essentially, do you know who you are? Do you know who your family is? Do you understand the power or property that you're giving? And if the answer is yes, you can create a new power of attorney. But if the answer to that becomes no, or if the person is unwilling to, a guardianship action becomes the only option, where we're saying to the court, this person can no longer manage their affairs, and we're asking the court to strip them of their legal autonomy. It's an extraordinary remedy and something that no family wants to get involved in if there's any option. And having power of attorney in place is the most protective thing against that.
Got it. Thank you for explaining that.
Of course.
Two questions. I think it's important for the audience to know. This one is, can you explain elder law care, what you do in regards to that, and who you're looking to help for that?
So elder law is one of these concepts that's out there that doesn't have a really tight definition. And you'll see different elder law attorneys who do different things from each other. Use the term elder care. There's some law firms that can offer essentially full service elder care placement, where they'll help with the legal Medicaid issues and help with the pragmatic issues of finding a nursing home bed and all the transitions involved. We don't really do that here with the care placement piece. We only focus on the legal issues. And so for us, what elder law typically means is advising on long-term care and Medicaid issues, because for most people, maybe we should back that up and talk about what long-term care is, because that's really the big ticket item here. Well, long-term care is nursing home care, is typically what we're talking about. And it's incredibly expensive. That if, for a New Jersey resident, you are probably doing very well if you're paying only $10,000 a month for long-term care. Most people cannot afford long-term care, or not for very long. Most people also don't have long-term care insurance. If someone has the health and financial situation to afford long-term care insurance, that is an excellent buy, because it puts a lot of options on the table that people without it don't have. And because the problem is that no one, unless they're really very wealthy, can pay for long-term care for very long. The challenge also is that if you can't pay for it, for most people, Medicaid is the payer of last resort. If someone has a wartime service record or their spouse did, they may have access to veterans benefits, a VA long-term care benefit. But that's a very specific subset of the population. Most people don't have access to that benefit. And Medicare will not pay for any long-term care, really. It's a little more complicated than this, but there's essentially a 100-day long-term care lifetime benefit that Medicare will pay for. So if someone goes into a facility, they start using up their Medicare facility days. And if someone is trying to stay out of a nursing home, what will typically happen, if they're trying to stay at home, they're managing their health issues at home as best they can, and things start to escalate. Their symptoms become too difficult to manage, and they end up in the hospital. Hospital discharges them, gets the symptoms under control, and discharges them to a subacute rehab. The question then is, can the person make progress in rehab? Medicare will stop paying if they do not. Because if they do not, what's the rehab doing? And at that point, the person needs long-term care based on the structure of our system. But who's going to pay for it? Because Medicare isn't, and most people aren't starting with a Medicaid benefit. To complicate issues, every state has their own Medicaid system. Medicare is a federal program. Medicaid is nominally a federal program. It's set up by federal law, but the implementation is all done at the state level. So state by state, there's very, very different programs. And crossing the New York-New Jersey border has major ramifications on Medicaid and how to qualify, who can qualify, what the necessities are. And so if someone has any option to, before they're making this decision, explore different states, because maybe they have multi-state property, that can be very well worth doing. We have a very difficult system in New Jersey that essentially, if we're talking about an unmarried person, they need to have $2,000 or less to their name and be making under about $2,800 a month gross, including things like pension, Social Security. And that $2,000 is going to look at people's retirement accounts, anything that can be turned into cash. Whole life insurance has a cash value on it, so it must be liquidated in order for someone to qualify, regardless of whether that makes any sense economically. The difficulty and complexity is even worse when there's a spouse, because there is spousal impoverishment protections, but what that looks like is very complicated, at least in New Jersey, that we can protect some resources, we can protect some income, often we can protect a lot of income depending on exactly the scenario, but grappling with the system is very hard. Even for attorneys, figuring out what the law is in Medicaid is not a trivial task. When I first started looking at this area of the law, it was overwhelming to even get my bearings. And so I think about how challenging it is for lay people who are often just thrust into their system and handed an application by a nursing home or social services and fill it out. But they don't know what's going to be happening on the other side of that, what that analysis of the application is going to look like. And so to go back, there's law firms where they're looking at basically how do we get someone into a nursing home, because they're doing that care management piece. A lot of our clients are either needing advising further out. They're doing long-term advising. They need to understand how the Medicaid system works. Or the people who are already in a facility or need to be in one imminently. And so Medicaid is needed yesterday. And we help people qualify in that circumstance. And, not all elder law firms do that. And I think especially ones that might hold themselves as elder care attorneys, because they're looking at a little bit of a different lens. We do what are called, it's not really planning, really, but people call it crisis Medicaid planning. We're doing Medicaid planning right now while the crisis is happening. And it's often just trying to make the best of whatever the situation happens to be. Because unless you're an elder law attorney, you're probably not living your life with Medicaid planning in mind. You're not worrying about, can I prove how I spent my cash? Can I prove why I wrote this check to my family member? Oh no, I wrote a check to cash for a tradesperson who preferred to be paid that way. Can I prove where that money went? All of that stuff becomes a big, big issue when someone's applying for Medicaid. And the things that become issues are not things that are illegal. They're not things that we have any other problem with other than in this context. So there's no reason for people to be thinking, oh no, I'm withdrawing $600 in cash from my bank account every month. That adds up to a lot of money. How am I going to prove how I spent it?
One of the topics I want to talk right at the end, Josh, is I think this is one of the things that makes Skylands Legal very unique is your service for Social Security disability. Can you explain what that is and what that isn't?
Sure, maybe. So Social Security disability is the federal disability program. It's different than state disability programs. It's different than workers' comp. Those are their own bodies of law. Often different lawyers. Sometimes there's overlap with those, but we don't handle either of those. For instance, Social Security disability is for people who have a work history and can no longer work because of a health issue. And we're talking about only permanent total disability. Now, permanent's a funny word because if someone stops being disabled, they lose the disability benefit and should return to work. But that's a minority of people where they have a condition that's so disabling that it's going to put them out of work for a year or more, but they may recover. Now, does it happen? Sure. And that's the goal frequently for a lot of clients, is to eventually be able to return to work. But for those who can't presently work or who may never be able to work, it's a support system. There are two Social Security disability programs. There's SSDI, Social Security Disability Insurance, which is really what we've been talking about. It's either based on your own work record or a parent's work record. And it is a form of Social Security. There's also supplemental security income, which is best thought of as welfare for people with disabilities and elderly people. There are strict financial requirements. And the benefit programs are different from each other in terms of the financial components, but they're looking at that same question of, can someone return to work? Like Medicaid, it's something where you can just go right online and apply. You go to myssa.gov or whatever it is, and you can apply for disability right there. But what happens then? If you just read the information at face value, it sounds like what's going to happen is that Social Security is going to investigate your medical status, that they're going to send out records requests to everybody. They're going to gather all the evidence and do a careful analysis. Well, they may send out some requests to the doctors that you list, but ultimately it's the applicant's responsibility to provide the complete medical record and complete explanation. And for someone who's struggling with a health issue, these can be major barriers. And so attorneys can provide assistance both at the essentially nuts and bolts administrative level. We're going to help you put the application together, but more importantly at the strategic level. Let's make sure that we're framing your disability in the way that is most helpful for Social Security to analyze it. Because the person may not know what the strongest pieces of their claim are. They have only their experience of their disability. And I'm thinking of a client who, if asked, would tell you that their mental health is the thing that is preventing them from working. But when you look at their claim objectively, their mental health challenges all relate to the physical disability, which is actually the thing preventing them from working. And if that's clearly presented to Social Security, they have much better odds of receiving a benefit. I don't know if that answered your question.
Yeah, it did. I think that was helpful. And I know sometimes people contact you for things that are not related to Social Security disability, like Social Security questions. But you don't deal with those. It's more disability related to Social Security.
Yes.
Right.
Now, that's true. Sometimes though we're able to help with some general Social Security questions, but that's typically if it's relatively straightforward. And often, depending on what the question is, there may not be really any assistance we can give, because often it's that people are really just not understanding the information that they're getting from Social Security, but we can often get people pointed in the right direction.
Great. So Josh, if people are looking to create, a will and do a consultation with you, how can people get contacted with Skylands Legal?
Sure. Well, we pride ourselves on working with people in whatever way is best for them. So you can call us on the phone at 973-970-9583. You can reach out to us at info@skylandslegal.com or visit us online at www.skylandslegal.com. You could write to us in the mail if you preferred. 191 Woodport Road, Suite 4, Sparta, New Jersey, 07871. And really the best way, though, is to give us a call or send us an email and set up an appointment so that we can have an in-depth conversation about the person's specific situation, specific needs, and what they should be taking into consideration.
Awesome. Thanks, Josh. Thanks for doing this.
Thanks, Raj.
Awesome.